All right, I'm going to have all the advocates raise your right hand. We're going to swear in before we proceed. So if all the advocates could just raise your right hand and indicate by saying I do. All right, I'm going to have all the advocates raise your right hand. We're going to swear in before we proceed. That's the YouTube going, okay? Sorry about that. So can you guys still hear me now? Okay. If you swear, do all the advocates swear to abide by the rule of this proceeding and conduct yourself in a manner that is honorable to this forum?
I do.
I do.
I do.
I do.
Great. I heard 4 I do's there, so perfect. So we're now calling the case number 082263, Cam Donaldson versus Karen Bassia. Are there any housekeeping matters that we need to attend to? And I guess I'll take entries of appearances, starting with the plaintiff before we jump into that.
Yes, Your Honor. Good evening. My name is Erica DeMeglio, and together with my co-counsel, Sarah Morris, we represent the plaintiff, Cam Donaldson.
Okay, great. And what is your team name?
Tory's Peak.
Tory Peak. Okay, that's for the plaintiff, Tory Peak. How about for the defense?
Good evening, Your Honor. My name is Lazaro Aguiar, and alongside my co-counsel, Evan Jefferson, we represent the defendant in today's case, Karen Bassia. Our team name is Blanca Peak.
Blanca Peak. Great. Thank you both. And starting with the plaintiff, are there any housekeeping matters?
Yes, Your Honor. Due to the virtual nature of this trial, may we assume that opposing counsel has already seen all exhibits?
I have no issue with that. I think that's fine.
Further, may we remain seated during objection so that we remain within view of our computer cameras?
Yes, you may.
The plaintiff would also like to invoke Rule 615, the constructive sequestration of all witnesses, with the exception of party representatives. The plaintiff's party representative is Cam Donaldson.
Thank you. And yes, I will enter a sequestration order pursuant to Rule 615. That will be constructive, of course.
May we also assume that each witness already has all potential exhibits in front of them?
That is fine. That's fine, I think, unless anyone has an issue with that.
And
No,
finally,
Thanks.
finally, may we assume that all witnesses are constructively sworn?
Yes, all witnesses will have been sworn in.
The plaintiff has no further housekeeping matters.
All right, any housekeeping matters from the defense?
Yes, Your Honor. When we're publishing to the jury, would you like us to use the share screen feature?
If you're comfortable using that share screen function, it's really helpful to us. So I would prefer that if you guys are comfortable with it and if technology permits.
With that, Your Honor, defense is ready to move the motions in limine.
Okay, great. I'll start back with the plaintiff for any substantive motions. Plaintiff, when you're ready.
The plaintiff would like to request that the court take judicial notice of Lou Donaldson's request for a temporary restraining order under Federal Rule of Evidence 201. The temporary restraining order can be found on page 55 of the case packet and is numbered under the base numbering system as 0016.
So you're just asking that I take notice that a request was made for a temporary restraining order under 201?
Your Honor, we're asking that you take notice of the document as a whole.
Okay, defense, what's your position on me taking judicial notice of the document?
Yes, Your Honor. We have 2 grounds for which we would not want evidence of this being on the record. The first ground would be hearsay, and there's 2 layers of that. And the second is improper use of character evidence, if I may be heard.
I think I understand both of those objections, Ms. DeMeglio, and I apologize if I'm not saying that correctly. What's your position on hearsay and 404?
Your Honor, to start with the evidence of improper character evidence, the plaintiff contends that there is no improper character evidence within this document. Defense has not elicited any reasons why the court should assume that it's being shown for action and conformity therewith. Further, Because this is a document from the District Court of Statesville, and it is an official document, as such, its sources can be accurately and readily determined under Federal Rule of Evidence 201, so its accuracy reasonably cannot be questioned.
I don't think the accuracy is at issue. I think to the 404 piece, you're telling this court that you're not offering it for propensity. What purpose are you offering it for?
We're offering it to show that Lou Donaldson had requested a temporary restraining order shortly before his disappearance.
Okay, and what's the response to hearsay?
Your Honor, it's not hearsay because it's not being offered for the truth of the matter asserted. We're simply offering it for the fact to show Lou Donaldson's state of mind at the time that he made the restraining order request.
Okay, and Mr. Aguilar, what's your position on that?
Yes, Your Honor, is that there's two grounds of hearsay on this. So the first layer we do not dispute. That's going to be the statements that Karen Beja makes to Lou Donaldson, which is covered by the party opponent. It's the second layer we're objecting to. Opposing counsel is going to be using that for the truth of the matter asserted. It's not an exception under Federal Rule of Evidence 8033, then existing mental state of mind. It doesn't go to Mr. Donaldson's motive. They're using this purely to draw that improper use of character inference that because she was likely threatening in the past, that therefore she threatened Mr. Donaldson in this particular instance. They're using that for their propensity argument, and it doesn't meet the proponent of 8033.
All right, I'm in a reserve ruling on this, but at this time I'm sort of inclined not to allow it. I don't think there's been, obviously I don't know this case, but I have concerns about foundation and the use of it. It's hard for me to determine what purpose this is going to be used for at this time, so I'm not going to allow it now. Certainly feel free to lay more foundation, Ms. DeMaglio, in your case in chief, and we can address this at that point. But for now, I'm not going to admit this temporary restraining order at this point.
Yes, Your Honor.
Any other substantive motions?
Yes, Your Honor. Plaintiff requests that the court admit Carl Bannister's patrol vehicle maintenance report form, which is previously marked as Exhibit 0017 under Federal Rule of Evidence 8038.
Okay, so you're asking me to admit the maintenance report form for Carl Bannister?
Yes, Your Honor.
All right, response to that, and I guess you're asking me to admit it under 8038. You're preemptively guessing there's going to be a hearsay objection?
Yes, Your Honor.
All right, response to that.
May I have one moment, Your Honor?
You may.
Your Honor, we have no objection to the admission of that document.
Okay, based on that, we will admit then the Sheriff's Office maintenance report form as just a stipulation, it appears. Is that an exhibit that we can reference as an exhibit number?
Yes, Your Honor. Plaintiff moves to admit what's been previously marked as 0017 as Plaintiff's Exhibit 1.
Okay, Plaintiff's 1 will be noted as the maintenance report form, and that was admitted via stipulation. Any other substantive motions from the plaintiff?
Not at this time, Your Honor.
All right, thank you. Any substantive motions from the defense?
Yes, Your Honor, at this time, defense moves in limine to bar any testimony about a prior will, if I may be heard.
You may.
Any evidence, we have it on a good faith basis that there will be testimony that comes out in trial today about there being a prior will. That will is going to be an out-of-court statement and is barred by the hearsay rules.
All right, do you have a response? Ms. Morris, I take it you're responding to this?
Yes, Your Honor. With regard to the prior will, we believe that it is admissible under 803.14, as this is a record of a document that affects an interest in property.
Okay, what's your response, Mr. Jefferson, or sorry, Mr. Aguilar, on the lost will? And
Yes, Your Honor. In order for that to be admitted under proponent B of 803.14, the record has to be kept in public office. it is my understanding that they won't be able to prove that. There's no mention of that being kept in a public office. Therefore, that exception is unapplicable.
Okay. I think this is one of those that we're going to need a little bit more foundation, especially if your position is that you're not sure they can lay the foundation. So I'm going to reserve ruling on the prior will for testimony and see if the foundation can be laid. So I'll reserve ruling for that.
Yes, Your Honor.
Any other substantive motions?
Yes, Your Honor. The defense moves in limine to bar from introduction into evidence a letter written by Miss Samantha Lane, who was one of the witnesses who attested to the signing of the will and who signed the will. We move to bar this from introduction into evidence because it is hearsay. May I be heard, Your Honor?
You may.
Your Honor, as I stated, Miss Samantha Lane was one of the attesting witnesses on the will and signed it. In preparation for this case, Miss Lane spoke with our expert in today's case, Chris Renard. When she met with our expert, she told our expert that she had seen Lou Donaldson sign the will and that she had in fact signed the will. Following that, and at a point subsequent to that, she wrote a letter to our expert recanting and saying that she did not see Lou sign the will and that she only signed because she was coerced. Your Honor, this is an out-of-court statement being used for the truth of the matter asserted, and so we move to bar this letter written by Samantha Lane from being introduced as evidence.
All right. In response to the letter from Samantha Lane.
Plaintiff has no objections to that motion.
Okay, so the letter from Samantha Lane will be excluded by stipulation. Is that an exhibit that we can reference?
Yes, Your Honor.
Number, okay. What number will that exhibit be? Is it pre-labeled or do we not have pre-labeled exhibits?
Give me 1 second, Your Honor.
No problem. It's just easier if we can reference, exhibit 1 is stipulated, exhibit X is excluded by stipulation.
It's base number 008 on page 41 of the case packet.
Okay, that's good enough. All right, so that will be excluded by stipulation. Any other substantive matters?
No, Your Honor.
All right, are the parties ready to proceed to openings?
Yes, Your Honor.
Okay, and just so you know, for openings and closings, I will stop my video and mute myself. That's just for openings and closings. Everything else, I'll be muted unless I need to weigh in, but my video will be up. In part, that's so you know if I drop off, you'll be able to tell. And I would ask that everyone also keep themselves on mute unless you're the advocate that's currently speaking, okay? The well is yours whenever you're ready, Ms. Morris.
When someone steals something, they must be held accountable. That's what this case is about, as you will learn here today. You see, we are here for 3 reasons. Because of a murder for which the defendant had a clear motive, and as a result, a son is in mourning. You will hear from the plaintiff, how the defendant has stolen everything from him. She's stolen his livelihood, his business, and most importantly, his father, Lou Donaldson. Members of the jury, my name is Sarah Morris, and I, along with my co-counsel, Erica DeMeglio, will prove to you today how the defendant, Karen Baja, is responsible for the death of Lou Donaldson and the suffering it has caused his son, Cam. Allow me to take a few moments to share what you will learn today. Lou and Cam Donaldson were incredibly close, not just as father and son, but as business partners. You will hear from our client how he and his father built Wild Wild Life, a big cat sanctuary from the ground up. Cam poured everything into this business, and he spent 20 years as his father's assistant. That Friday afternoon, as Cam said goodbye to his father after the workday, he had no idea it would be the last time he would do so. Which brings me to the first reason we are here today: murder. Lou Donaldson was married to the defendant, but as you will hear, their relationship was severely troubled. Lou was a private man who was known to function best when he could take time to himself, and he was known to get away from it all from time to time. In fact, you will likely hear from the defense today that he allegedly had a mistress, though there's no evidence supporting her existence beyond the sole word of the defendant herself. In the weeks and months leading up to Lou's disappearance, things were getting increasingly worse. They got so bad that at one point, Lou Donaldson went as far as to request a restraining order, a court-issued document asking to be kept away from his wife. A few weeks later, the pair fought again, and once more, Lou felt fear. In fact, he went as far to tell our client that if something is to happen to me, be sure to have the police look into Karen because she will be responsible for my death. Lo and behold, 2 weeks later, Lou Donaldson vanished forever. Now, Lou Donaldson was never seen again after August 17th, 2012, but the defendant certainly was. You will hear how she left her home in the middle of the night on August 18th at 3 a.m. to buy formula for her tiger cubs at the grocery store. On the way home from this curious errand, her car broke down, and instead of calling her husband to pick her up on the side of the road, she called her brother, Officer Carl Bannister, a sheriff's deputy who was on nearby patrol that night. Now, Officer Bannister says that he picked Karen up on the side of the road and dropped her off at her home. But the evidence will show that the vehicle tracker on Officer Bannister's patrol car showed no movement between 3:20 a.m. and 6:30 a.m. that night. Officer Bannister says that he dropped the tracker off for maintenance the next morning. But you will hear that when he dropped it off to be fixed, it was fine. The tracker was in working condition. Now, the next morning, Cam Donaldson awakes to the distant sound of a buzzing alarm just as the sun was rising. It was the security system at Wild Wildlife, so Cam jumped in his car to see what was wrong. When he arrived at the office, it was clear that someone had broken in. The chain and its front padlock had been snapped, and the back entrance to the office had been destroyed. And who does Cam see walking out of the office but Ms. Baja and an unidentified partner carrying with them lock cutters and a lockbox containing Lou Donaldson's original will. Now, at this point, Cam didn't know that his father was missing, so this incident seemed strange, sure, but not immediately sinister. But a week later, when Lou Donaldson's abandoned van and personal effects were discovered 40 miles away, Cam knew something was seriously wrong. Before he knew it, he had been fired from his job at Wild Wildlife. Ms. Baja had taken full control of the business, and his father was nowhere to be seen. That lockbox Ms. Baja was carrying, the one that contained Lou Donaldson's original will, suddenly it all made sense. Which brings me to the second reason we are here today, and that is the motive that the defendant had to murder Lou Donaldson. You see, in addition to the marriage problems and the looming divorce, there was a great deal of money at stake. Members of the jury, I ask that you pay especially close attention to the discussion of Lou Donaldson's last will and testament over the course of this trial. you will learn that Ms. Baja has produced a will that leaves all of Lou Donaldson's assets to her. But this will that Ms. Baja has relied on is notable for 3 important reasons. First, this will contains the phrase, "should I die or disappear." You will learn that the term disappear in a will is not only rare, it is nearly unprecedented. 2, the signature at the bottom of Lou Donaldson's will does not match the signature samples of Lou Donaldson's other signatures. And 3, this will that Lou Donaldson allegedly signed, leaving all of his assets to Karen Baja, was signed just 2 days after Lou Donaldson sought a restraining order against Karen Baja. Nevertheless, the Monday after Lou Donaldson vanished, Ms. Baja took control of Wild Wildlife, fired our client, and never looked back, leaving him without his livelihood, without his business, and without his father. Which brings us to the 3rd reason we are here today, and that is because a son is in mourning. Cam Donaldson will never see his father again. They will never share another Sunday dinner or another inside joke. Murder, motive, mourning. It will be up to you to decide whether it is more likely than not that Ms. Baja is responsible for the death of Lou Donaldson and the suffering it has caused his son. It is a tragic reality that an apology can't cure Lou Donaldson's son's mourning. Sorry won't bring Lou Donaldson back. But at the end of this trial, my co-counsel, Erica DeMeglio, will stand up and ask you to do the next best thing, which is to find the defendant liable for the murder for which she had such clear motive to commit. Because when someone steals something, they must be held accountable. Thank you.
All right, thank you, Ms. Morris. Would the defense like to present an opening statement?
Yes, Your Honor.
All right, thank you. Whenever you're ready.
May it please the court, opposing counsel, members of the jury. Nothing was ever enough for Lou. And the focus of today's case shouldn't be on the actions of Ms. Baja, but rather the focus of this case should be on the actions of Lou and how nothing was ever enough for him. Now, as for Ms. Baja, well, she didn't kill anyone. And members of the jury, that isn't just me telling you that. There have been 2 investigations into Mr. Donaldson's disappearance, one by the sheriff's department and one by the insurance company. And neither investigation ever concluded that Karen was a suspect. The focus of this case shouldn't be on the actions of Ms. Baja. The focus should be on Lou. And now I want to talk about Lou Donaldson. Lou was a self-made man. He was an entrepreneur. Lou started his career by selling used cars. And he was so good at selling used cars, they made a fortune. But this wasn't enough for Lou. Lou used that fortune to open the sanctuary. And by all accounts, the sanctuary did very well. But even this wasn't enough for Lou. So Lou went out and learned a new hobby. He learned how to fly planes. Lou would use this hobby to take business and personal trips all around the world. And one of these places that Lou would take these trips was to Costa Rica. Now, first, nobody really knew why Lou was taking these trips. But members of the jury, you'll hear for yourself today that Lou wasn't on a business trip. No. Instead, Lou had a mistress. Nothing was ever enough for Lou. And now I want to talk about Miss Beja. Throughout today's case, the plaintiff is going to try and paint Miss Beja as some greedy person. The plaintiff's going to try and say that Miss Beja went through the trouble of forging a will and killing her husband, all in the name of greed. But Miss Beja is going to take that stand today. And you're going to hear from Miss Beja, and you're going to see from Miss Beja that what she had, it was enough for her. And now I want to go back and talk about the will. The plaintiff is going to call a witness in today's case, and that witness is going to run through this handwriting analysis and conclude that that will is a forgery. But then you're going to hear from the defense's expert in today's case, Chris Renard, who has 20 years of experience in forensic document examination. And Mr. Renard's going to tell you that the will isn't a forgery. But more importantly, members of the jury, don't let the plaintiff confuse you with the will. Because this case isn't about whether a will was forged. This case is simpler than that. And now I want to explain to you what I mean when I say this case is simpler than that. The plaintiff must prove two things to you in today's case. They must prove to you that Lou Donaldson is actually dead, and they must prove to you that Karen is the one who caused Lou's death. That is their burden in today's case, and they must prove that to you by a preponderance of the evidence. That means that they must prove to you that what they are telling you is more likely than not the truth. Now, this case is simple because either they prove those two things to you or they don't. And if they don't, well, then this case is over. Now, the time will come today for you to decide what happened. And when you go back to deliberate and you review the facts of today's case, think about the actions of Lou and how nothing was ever enough for him. We ask that you find Ms. Beja not liable. Thank you.
All right, thank you. Would the plaintiff like to call their first witness?
Yes, Your Honor. Plaintiff calls Cam Donaldson.
Okay. And whenever you're ready.
Good evening. Please introduce yourself to the members of the jury.
Yeah, my name is Cam Donaldson.
Mr. Donaldson, how are you related to the defendant?
Karen's my stepmother.
Why are you here today?
After my dad disappeared back in August of 2012, I start to believe that Karen murdered him. I think she forged his will to leave her everything. I thought that she murdered my dad and had a motive to take everything from me, and that she should be held accountable for that.
I'd like to unpack that a little bit. Let's start with why you think Karen Baja had a motive to kill your father. Do you have any specific reason to believe that?
Objection, Your Honor. Calls for speculation.
Response to speculation.
Your Honor, if I may proffer, the
You may.
witness is about to testify to his relationship with the defendant. He's going to testify that he worked very closely with both his father and the defendant, and he's going to testify to the exact facts and circumstances that he believes led Karen Baja to murder his father.
All right, if you can lay a little bit more foundation, which it sounds like you're going to, I'll allow it.
Do you have any specific reason to believe that Karen Baja would have a motive to do that?
Every time I saw her at Wild Wildlife, she was playing with the tigers and she seemed downright obsessed with the cats. I guess she must have really loved it.
To be clear, what's Wild Wildlife?
Right. Wild Wildlife was my dad's business. It was a sanctuary for big cats. We had all kinds of cats there, but we mainly kept tigers.
Did you ever work there?
I did, yes. I worked at Wild Wildlife for about 20 years.
What was your role at Wild Wildlife?
I kind of ran the place for my dad, really. Anything he needed, I was doing for him. I was taking phone calls. I was ordering supplies, scheduling meetings, writing checks whenever we needed to pay anyone. Anything like that, that was all on me.
Why were you the one that was responsible for running the business?
My dad was a pretty busy man. He would always go flying off on various business trips here and there.
And what mode of travel did your father take on those business trips?
He would fly. He would fly a lot. He flew so much that he eventually started to fly himself places. Used his own planes and everything.
Based on your observations, how does your father's busy schedule affect his relationship with the defendant?
I mean, I'm not sure of all the details about the relationship, but whenever I'd see them together, they'd start to argue more and more often. I guess their marriage must have started to get pretty rocky. At least that's how it seemed to me based on their arguments. Eventually, my dad wanted to get a divorce.
How do you know your father wanted to get a divorce?
I mean, he was pretty open about it. I first heard him mention the idea to Karen in June 2012, about 2 months before he was murdered.
Was your father ever able to file for divorce?
No, as soon as the word divorce left his lips, Karen was really mad. She screamed, "I'll kill you." My dad ended up filing for a restraining order instead.
Was your father able to get that restraining order?
No, he wasn't. The court ended up.
Objection, Your Honor, to hearsay as to the restraining order.
May I respond?
Yes, you may. And is your objection to what the court said or the fact that he tried to obtain a temporary restraining order?
Yes, what the court said in the TRO.
Okay. Ms. DeMeglio, what's your response to what the court said?
Your Honor, we're not offering the fact that the court denied the restraining order for the truth of the matter asserted. We're simply offering it for the effect that it had on the listener, both Lou Donaldson and Karen Baja. As you'll see, Lou Donaldson knew that the restraining order was denied, and Cam Donaldson is going to testify about how that affected his father. Further, Karen Baja also knew that the restraining order was denied, and Cam Donaldson will testify about how that affected her actions.
Well, I think I'm going to sustain the objection. I think we've heard that there was a temporary restraining order that was obtained, and I think that that's the extent that we should go into this in light of the concerns with propensity and hearsay. So I will allow you to say that there was a temporary restraining order that was obtained. There was no objection to that by the defense, and that's the extent that I'm going to allow the evidence.
Yes, Your Honor. Do you recall any other arguments between your father and the defendant?
Yeah, there's one that really sticks out to me. It's probably about a month and a half after that restraining order, about 2 weeks before my dad was murdered.
What happened during that argument?
So we were all at work. I was up front, and they were in the back in the office, and I heard my dad bring up wanting to get divorced again. Karen was yelling and screaming. She seemed furious at the mention of it. She stormed out of my dad's office.
Did your father say anything in response?
Yeah, after that
Objection,
argument,
Your Honor, hearsay.
What's your response to hearsay?
Pursuant to Rule 8032, Lou Donaldson's statement is an excited utterance. As the witnesses just testified, Lou Donaldson had just been in an argument with his wife. His wife was screaming, yelling, furious, and the events made him excited enough to give rise to an excited utterance under 8032.
And just as an offer of proof, and will be constructively outside the presence of the jury, What will this witness testify to if allowed?
He's going to testify to the fact that his father instructed him to have the police look into Karen if anything ever happened to him.
Okay, and so the objection to that, Mr. Jefferson, was hearsay, correct?
Yes, Your Honor.
And Ms. DeMeglio, it's your position that this is 8032, an excited utterance?
Yes.
Okay. I think we've heard some foundation that this was a fight between him. Do you have the ability, between him and Miss Baja, do you have any foundation to lay that he was then excited in response?
Yes, Your Honor, I can lay that foundation.
Okay, why don't you go ahead and do that?
How did your father appear immediately after that fight he had with the defendant?
My dad was visibly shaken. I never seen him look like that before. He looked terrified. And I mean, this is a guy who works with tigers and leopards all day. He looked so scared.
All
Did
right,
he say anything?
in light of that foundation, I will overrule the objection. Carry on.
Did your father say anything?
Yeah, he looked me right in the eye. He told me, anything ever happens to me, be sure to have the police look into Karen because she will be the one responsible for my death.
What did you think when your father told you that?
I mean, after the restraining order thing and all the fighting, and then my dad told me,
Objection, Your Honor, to the relevance of that.
What's the relevance to what he thought of it?
Your Honor, this is a wrongful death action brought by this plaintiff. He has just testified that he was very close to both his father and the defendant. His opinion of what happened is incredibly relevant as it makes the fact that Karen Baja did murder Lou Donaldson more likely.
I have concerns about the relevancy of this. I'll give you a little bit of leeway, but otherwise move on.
Mr. Donaldson, what did you think when your father said that?
yeah, I mean, just given the restraining order thing and all the fighting, and then after my dad said that, I mean, it sounded to me a lot like he was really worried that Karen might try to kill him.
Let's talk about that. Specifically, why you think your father's disappearance was a murder. When was the last time you saw your father?
It was August 17th, 2012. It was a Friday. It was the end of the work week. I was staying a little bit late that night. He was packing up to go home. He told me he'd see me at work Monday. Asked me if I was planning on stopping by for supper on Sunday, but I never saw him again after that.
Did you ever try to figure out where your father went?
Yeah, of course I did. I mean, as his assistant, I keep track of all his financial records. I looked at them and there was some stuff in there that just didn't make sense.
Would you recognize those financial records today?
Yeah, of course.
Please turn to page 54 of the case packet to the document labeled 0015 and let me know when you're there.
Yep, I'm there. I see it.
What is that?
This looks like a copy of the bank statement that was my dad's account, dated from August 2012 up through September 2017.
Does it appear in the same condition as it did the last time you saw it?
Yeah, it looks about right.
Plaintiff moves the bank records into evidence. It's for identification purposes, it's labeled 0015. Plaintiff would like to move it in as Exhibit 2.
Any objection to Exhibit 2, the bank records?
No objection, Your Honor.
All right, Exhibit 2 shall be admitted.
Permission for my co-counsel to publish that exhibit to the jury?
You may.
What didn't make sense to you about these records?
Yeah, so the last day that I saw my dad, which was August 17th, you can see here, he spent about $940, a little over that, on animal supplies. I'm pretty sure that was food for the tigers. But after August 17th, he didn't spend a single cent, even though he had almost $100,000 left in that account.
Now, we heard during the defense's opening statement all about Costa Rica. Do you think it's possible that your father is alive and living in Costa Rica?
I just don't see that being possible. I mean, we were so close, and he never went more than a few days without contacting me. I have all of his bank records, and he never spent any money after he disappeared.
Do you think it's possible that your father attempted to fly to Costa Rica?
I don't think so, no.
Why not?
As far as I knew, anytime my dad was flying anywhere, he would tell me. And then when Karen and her cop brother went to get his van, they found his glasses in there. And since I was in high school, I only knew that he had that one pair. I didn't know of any others. Was blind as a bat without them, couldn't see a thing. So I don't think he could have taken off without them.
Now, after the last time you saw your father, how did you discover that he was gone?
So the first time that I suspected something might be wrong was about 2 days after I last saw him. I woke up that Sunday morning around 6 a.m. I just got a notification. The alarm had gone off at the Wildlife office. I immediately jumped out of bed, ran into my car, drove over there as fast as I could. I had a really terrible feeling in my gut.
What did you find when you got to Wildlife?
So when I walked up, the first thing I looked at the front gate. We have a padlock that we used to lock it. That padlock had been broken. I made my way past the front gate and went to the back entrance to the office. There I saw that back entrance had been ruined.
Did you call the police?
I didn't. We have our security system set up. It automatically notifies the police of any alarms, just like it notifies me. So when I had driven up to Wildlife, the police had come in right behind me. We were about to go in when Karen walked out with a man.
Do you know when the defendant got to Wildlife that day?
I mean, I don't know for sure. I'm assuming it was probably before me since she was already.
Objection, Your Honor. Speculation.
Sustained.
What did the defendant say to you and the police?
So she told the police that at that point she was the owner of Wildlife and that they should contact her attorney if they had any questions. She was grinning from ear to ear, and I was just standing in shock the whole time.
Why were you in shock?
I mean, I didn't think my dad was missing or was for some reason not the owner of Wildlife anymore. I didn't know anyone who did think that. I was expecting to see him at work on Monday, like he told me he would. But I mean, just 2 days after he'd last been seen alive, there was Karen walking out of the office.
Did the defendant have anything with her when she left the office?
Yeah, she was carrying a lockbox in her hands. I recognized it as the lockbox that I keep in the bottom drawer locked away at my desk in the office.
What did you keep in that lockbox?
I keep my dad's last will and testament in there.
Now, after the defendant took over control of Wildlife, did you continue to work there?
No, I didn't. She fired me, kicked me right out of the business.
Did anything else Karen Baja did at that time stick out to you?
Yeah, a couple weeks later, I think it was about a week later maybe, She went to pick up my dad's van. That's when they found his glasses and his keys that were still on his seat, and that's when I first got a sense that my dad might not be ever coming back.
How did you react when you found out your dad was probably never coming back?
Not well. I don't feel like I've even had the chance to mourn for my dad because of everything that this has put me through.
Finally, Mr. Donaldson, I'd like to talk about that mourning process and what it was like for you. After the defendant took the lockbox, what happened with your father's will?
I'm not sure what happened to the real one.
What do you mean, real one?
So the will that I had kept in the lockbox.
Objection, Your Honor. This real will, this reference to the real will is hearsay. It would be an out-of-court statement being used for the truth of the matter asserted.
Response to
Yeah.
that?
Your Honor, we're not offering this real will for any truth to any statements that it might assert to the way the assets would have been divided up in that will, which is the truth that that document asserts. Rather, we're offering it to show that it had an effect on the listener, which was Cam Donaldson, and showed that it was different from the will that Karen Baja produced later.
Okay, do you have a response to that, Mr. Jefferson?
No, Your Honor. So long as the discussion of the real will is limited to just the effect on the listener and is not offered for the truth of the matter asserted, then we have no objection to that.
Okay, based on that stipulation, then I will overrule the objection and with that limiting instruction that it is not to be used for the truth of the matter. Thank you. You can proceed.
What do you mean, real will?
Yeah, the will that I kept in my lockbox, the one that my dad had drawn up years before, it split all of his assets 4 ways. I got a quarter, my mom did, Karen got a quarter, and then Wild.
Objection, Your Honor. This is using I re-raise my objection. This is using the will for the truth of the matter asserted.
I think this is getting into the truth of the document because we're having this witness testify to the substance of it and saying that's how it was to be divided. So based on that, Ms. DiMeglio, do you have a response to the objection then?
Your Honor, the witness is simply testifying to what the will said so he can draw the parallel that the new will was different.
Okay, you had previously, you laid some foundation that this witness was controlled this was kept in a lockbox. He has seen it and reviewed it, correct?
Yes.
Okay. Based on
May I
that,
respond, Your Honor?
Sure.
Your Honor, the will that opposing counsel was referencing that was in the lockbox is the will that's presented here in court today. It's not this real will that opposing counsel is testifying to right now. There's a difference between those two.
Got it. Understood. Okay, so Ms. DiMeglio, then, sorry, based on that, do you have a response?
Your Honor, that's a question of fact for the jury. The plaintiff is asserting that the will that was in the lockbox is different than the will that's being asserted here in court today.
Okay, I think I'll overrule the objection, I think, and limit it. I think this witness can certainly say that the will he was previously made aware of was different than the will that it is now, and that's the extent to which we'll go into it.
Yes, Your Honor.
Thank you.
How was the real will different than the will that Karen Baja produced?
Yeah, the real will split the assets those 4 ways. My mom.
I re-raise my objection, Your Honor.
I'm going to overrule it based on my prior ruling.
How was the real will different than the will that Karen Baja produced?
Yeah, so like I was saying, the real will, it split my dad's assets 4 ways: me, my mom, Karen, and then the business itself, Wild Wildlife. The new will, the one that Karen showed up with later on, it just gave everything to Karen.
Why do you think that the will that Karen Baja produced wasn't written by your father?
I mean, it didn't leave anything to me, his only child. It didn't leave anything to Wild Wildlife, the business that my dad built. And the will that I'd originally had didn't have anything about, disappearing in it. This will that Karen brought in said if I should die or disappear. And I never saw that kind of language before.
I re-raise my objection, Your Honor. At the very least, there is a truth of the matter asserted purpose here, and so then I would amend my objection to 403.
Okay, so just so I'm clear, we're referring to something as the real will, and then we're referring to something as the new will. The real will is the lost will. Is that correct? The original will and testament, and then we have the new will that has shown up after the fact. Is that correct?
Yes, Your Honor.
Mr. Jefferson, is that correct?
Yes, Your Honor. We have the will that will be presented here in court today, and then the one that the witness is testifying to, that the witness is saying was previously was before this one that's in court today.
Okay, that's the original will, right?
Yes.
Okay, I'm going to overrule the objection.
Why do you think the new will wasn't written by your father?
Yeah, the new will didn't leave anything to me. I'm my dad's only kid. Didn't leave anything to the business that he had built, Wild Wildlife. Just left everything to Karen. Then on top of that, it had this language in it: if I should die or disappear. My dad's original will definitely didn't say anything about disappearing. That was something that was added in later on.
Do you know when your father's life insurance was paid out?
Yeah, so he was officially missing. No one could find his body anywhere. So you had to wait 5 years to have someone declared legally dead. 5 years to the date, Karen went to the court, had him declared legally dead, and applied for a $5 million life insurance policy that exact same day.
In addition to the business and the life insurance policy, did the defendant take anything else?
I mean, she took my dad from me. He was everything. He taught me everything I knew about hard work, and I just don't have that in my life anymore.
What was he like as a father?
He was the best. He taught me about hard work, gave me my first job opportunity, built this business that I hope one day I would get to take over and continue that legacy.
And finally, Mr. Donaldson, how has the loss of your father affected you?
It's like I've lost a part of me. I mean, I've thought about him every single day since I've lost him. He never got to meet his grandkids, never going to get to call him and ask him for parenting advice, or call him and ask him for his barbecue recipe. I miss him.
Thank you, Mr. Donaldson. Your Honor, I have no further questions at this time.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed, Your Honor?
You may.
Cam, your father started his career by selling used cars. Is that correct?
Yeah, he started with nothing and built himself up through the used car business.
And your father was so good at that he made a fortune just by selling used cars.
Yeah, that's how he started making his money.
And he used that money to open the sanctuary.
Yeah, working with animals was always his real passion.
So you would agree with me that your dad was an entrepreneur?
Yeah, taught me everything about the value of hard work.
Now I want to talk about the investigator you hired in this case. You hired an investigator, is that correct?
Yeah, I did. I figured that Karen might try something, and something was a little bit fishy, so I wanted to make sure I had my bases covered.
Now your father was last seen in 2012, is that correct?
That's right.
But you waited until 2017 to cover your bases and hire an investigator.
Yeah, I mean, I didn't think Karen was going to try anything until right before she was.
Now I want to talk about your work at the sanctuary. You worked there with your father as you testified?
Yep, worked there with him, did everything for him.
You worked there for 20 years?
Yep.
And as you testified on direct, you ran the books,
I did. I ran the books.
scheduled your dad's meetings.
That's right.
So you would agree with me that you knew pretty much everything about your dad.
Yeah, I've always figured that I did.
Now, you know that your dad would buy and sell planes.
Yeah, he did trade a lot in planes.
And he would often do this without properly registering those planes.
Objection, improper character evidence.
Response to 404.
Your Honor, this is not eliciting a character or a trait, Your Honor. This goes to something else. This is not making a propensity argument. This is going to show that Mr. Donaldson may have had potentially several planes that were not registered and that people didn't know about, which would have allowed him to have gone to Costa Rica undetected, as is the defense's case in this theory.
Okay, understood. Overruled. Overruled.
Mr. Donaldson, your dad wouldn't properly register these planes. Is that correct?
No, he never did.
And you also know that your father would fly even on a suspended pilot's license.
Yeah, he never told me the story behind that. He always said he would, but
You also know that your father would fly without logging a flight plan.
yeah, but he'd always tell me.
But you don't even know where he went after work on August 17th, 2012.
No, I assumed he just went home like he always did.
Now, I want to talk about Miss Beja and your father's marriage. You didn't live with them. Is that correct?
No, Karen didn't come into my life until after I was moved out.
So you weren't around them 24/7?
No, I wasn't. Only when they were at the sanctuary together with me.
So you would agree with me that you don't know everything there is to know about their marriage.
I mean, I guess I don't know everything.
And you didn't even know that your father had a mistress in Costa Rica.
My dad never seemed like the type. I never thought he could. I never thought he would.
And now I want to talk about the will. Your claim is that Karen altered the will. Is that correct?
Yeah, she changed it.
But you don't have any copies of your version of the will?
There was only one copy and it was in the lockbox she took.
Just to clarify, Cam, you don't have any copies of your version of the will. Is that correct?
No, I don't. She took the only copy.
You don't have any records of your version of the will?
No.
And no one else can attest to your version of the will but you. Is that correct?
I mean, my dad could have if he was still here, but other than that, no one.
No further questions, Your Honor.
All right, thank you. Any redirect?
No redirect, Your Honor. We ask that Mr. Donaldson be excused.
All right, Mr. Donaldson, you may be excused. Thank you so much for your time. Plaintiff, you may call your next witness.
Plaintiff calls Taylor Pride.
All right, Ms. Pride, whenever you're ready, the well is yours, Ms. Morris.
Good evening. Would you please state your name for the jury?
Yes, my name is Taylor Pride.
What do you do for a living, Ms. Pride?
I'm a private investigator.
Why are you here?
Well, I was hired by Mr. Donaldson to investigate the disappearance of his father, Lou Donaldson, as well as the authenticity of the will in this case.
Before we get into the details of this case, I'd like to just talk a little bit more about your background. How long have you been a private investigator?
I've been a private investigator for 4 years.
What did you do before then?
Before that, I was a detective with the Pioneer Police Department.
When did you join the police department?
I joined back in 2000.
And when you were an officer and a detective, did you focus on a specific area of crime?
No, I actually was able to hop around to a number of different departments in the police police department, anywhere from economic crime to investigating murders.
Do you have an experience investigating forgeries?
Yeah, so like I mentioned, one of those units I was in was the economic crimes unit. When I was assigned to that unit for a few years, I was able to investigate a number of forgeries.
Does that entail any specific training?
It does, yes.
Can you tell us about that training?
Yes, so part of that training is attending a 2-week seminar, kind of learning basically how to analyze and compare handwriting samples, and then you become board certified through passing that seminar course.
Do you have to keep up to date on this training?
Yes, you do.
How do you do that?
So I keep up to date by attending an annual 8-hour course. I keep up to date on the current literature in the field, as well as I get recertified with the board who puts on that training every 4 years.
Have you testified as an expert witness before?
I have, yes.
How many times?
15.
And Ms. Pride, over the course of your investigation into this case, can you tell us a bit about the methods and sources you used?
Of course. So I was able to conduct several interviews with relevant witnesses. I reviewed documents pertinent to Lou Donaldson's disappearance, and I performed a forensic document examination upon the will.
And are these methods standard to the fields of private investigation and forensic document examination?
They are, yes.
And did you apply them as they are relied upon in your field?
I did.
At this time, Your Honor, I'd like to proffer Ms. Pride as an expert witness pursuant to Rule 702.
And what are you offering this witness as an expert in? What's your tender?
In the field of private investigation, law enforcement, and as a forensic document examiner.
Private investigation, law enforcement, and a forensic document examiner?
Yes, Your Honor.
All right. Any objection or voir dire based on that tender?
No voir dire, Your Honor, but I would just have them specify what, I mean, in regards to law enforcement, they've laid testimony to economic crimes and investigating murder. So I asked that it be limited to those purposes that this witness has, those crimes that he's previously dealt with, not just law enforcement in general.
Okay. I certainly think this witness has sufficient expertise and knowledge to be tendered as an expert in law enforcement. I understand that that's kind of a vague term, but I'm going to overrule your objection. But I think feel free to re-raise it if you think she's really going outside of maybe a reasonable tender for law enforcement. But I think that coupled with the private investigation tender and this witness's background, I think we all know what purpose that's going to be served. But feel free to renew your objection if you think it's just drastically beyond the scope.
Yes, Your Honor.
All right, so this witness will be tendered as an expert in private investigation, law enforcement, and forensic. What?
Document examination.
Great, thank you.
Thank you, Your Honor. Now, Ms. Pride, let's get into the details of this case. When did Lou Donaldson go missing?
He went missing back in 2012.
And in addition to your investigation into his disappearance, have there been any other investigations?
Yes, the Pioneer Sheriff's Department opened an investigation back in 2012 when he went missing.
In your opinion, what do you think about this investigation?
I don't believe that the Pioneer Sheriff's Office did a very thorough job. In fact, they really kind of missed the mark by not investigating the disappearance as a murder.
And is this an ongoing investigation?
It is, yes.
And why do you think they missed the mark investigating this as a murder?
Well, I should preface this by saying because it's an ongoing investigation, they've actually released very limited information about their investigation. But essentially, what we do know is that there's significant evidence that Ms. Baggia killed her husband.
What type of evidence is there to support the theory that Ms. Baggia killed her husband?
Mostly the temporary restraining order that was sought by Mr. Donaldson against Ms. Baggia.
How did you come across this temporary restraining order, Ms. Pride?
So I was able to get it through what the Sheriff's Department has been able to release.
And if I might direct you to page 55 of the trial packet, and let me know when you've got it in front of you.
Okay,
What are you looking at, Ms. Pride?
so I'm looking at, 1 second, that restraining order.
And is that restraining order in the same condition that it was when you looked at it during your investigation?
It is, yes.
Your Honor, at this time, plaintiff moves to enter the temporary restraining order previously marked as 0016 as plaintiff's exhibit 3.
Okay, and this is the entire temporary restraining order document that we're moving to admit?
We would move to admit that, Your Honor.
Okay, response to the request to admit the temporary restraining order.
Yes, Your Honor, I have two grounds. The first is hearsay and the second is improper use of character evidence, if I may be heard.
You may.
There are two layers of hearsay in this document. The first layer, I do not dispute. Those are the statements that Karen Beja makes to Lou Donaldson. That's covered by the party opponent. I don't dispute that. The second layer of hearsay is when Lou Donaldson is writing down these statements onto the restraining order. That is the hearsay that I'm objecting to, the second layer. In addition, they're using this to show past action and conformity therewith, that because she was allegedly violent in the past, therefore she was violent in this case and is barred under 404.
All right, Ms. Morris, I'll give you the last word on this.
Yes, Your Honor. Regarding to 404, we have no interest in that. We are simply moving to admit the contents of the temporary restraining order under the public records exception to hearsay. This is a public document. It was filed in a courthouse and unfortunately denied by a judge, but it clearly falls under the public records exception to 803.
I disagree that it falls under the public record exception. I also have serious concerns about the propensity evidence of this. So I'm not going to admit this exhibit. I think we've heard that there was a temporary restraining order that was sought. So I'm going to sustain the objection.
Yes, Your Honor. Ms. Pride, as a law enforcement expert, can you explain just what a temporary restraining order means?
Basically, a temporary restraining order is something that is sought by one party to protect them against another party.
And in addition to the fact that Lou Donaldson sought a restraining order against the defendant, is there any other evidence that supports the theory that she murdered Lou Donaldson?
Yes, basically, along with that restraining order, there is the knowledge that Mr. Donaldson was seeking a divorce from Ms. Bagia.
Yes, and yes, definitely, Ms. Pride. And beyond the marital problems in the Donaldson-Baja household, was there any other evidence that you looked at that lent to this theory that she murdered her husband?
Yes, in addition to
Foundation, if I may be heard.
You may.
This witness has the attorney's question called for specifically that the problems of their marriage. This witness hasn't laid any foundation, their knowledge on that. Therefore, if they're going to dive into the marital problems, I ask that that foundation be laid.
Okay, Ms. Morris, go ahead and just lay the foundation on what evidence this expert came up with to figure out what was going on with their marriage. And I think that that'll be fine. So it's just a foundational issue.
Certainly, Your Honor. Ms. Pride, in your experience, if one spouse seeks a temporary restraining order against another spouse, is that fair to say that there are marital problems going on?
I would definitely say it's not.
Objection, Your Honor, to beyond the scope. This witness has not testified that her expertise is in law enforcement. It's not dealing with restraining orders, a marriage counselor. She's diving beyond the scope of their expertise on this question.
Your Honor, may I be heard?
I'm going to overrule the objection. I certainly think that this expert can conclude that because there was a temporary restraining order that was sought, that there are some issues maybe in the marriage. I certainly think that's an argument that can be made. So I'll let the jury decide that.
Moving on from the restraining order, Ms. Pride, what other evidence was there to support the theory that Ms. Baja murdered Lou Donaldson?
Yes, there was a significant financial motive in this case.
Can you say more about that financial motive?
Of course, it was laid out in the last will and testament that Ms. Bagia produced.
And how did you come across this will, Ms. Pride?
I gained access to it through Chris Renard, who was the insurance investigator in this case.
Now, would you please turn to page 53 of the trial packet?
Yes.
What is that document?
So this is that last will and testament that was produced by Ms. Bagia.
And is it in the same condition that it was when you reviewed it during your investigation?
It is, yes.
At this time, Your Honor, plaintiff moves what has been previously marked 0016 into evidence as plaintiff's exhibit 3.
Any objection to exhibit 3?
No, Your Honor, I have no objection to the
All right,
will and
exhibit
testament.
3 shall be admitted.
Your Honor, if my co-counsel may share her screen at this time, published to the jury.
She may.
Now, Ms. Pride, did you review this will as part of your investigation?
I did.
Did anything stand out to you about it?
Yes, two things. The first was the language used in the will, and then the second was the signature provided by the signature that says Lou Donaldson.
Let's take those one at a time, but first the language. What stood out to you about the language?
Well, so the first piece that stood out was the language that of die or disappear.
Is that notable?
It is.
Why?
Well, I've never seen the word disappear in a will before.
And how many wills have you reviewed over the course of your career, Ms. Pride?
Hundreds.
And in the hundreds of wills you've reviewed over the course of your career, you've never seen the term disappear?
Never.
I'd like to move on to the signature that you discussed. Did you analyze this signature in your capacity as a forensic document examiner?
I did.
And how did you go about doing that?
So there's several steps in doing a forensic document examination. The first is obtaining known samples of the party whose signature it's allegedly it is.
And did you collect these types of samples from Lou Donaldson?
Yes, I was able to collect two samples, one that was on his driver's license and then the signature that was on the restraining order paperwork.
And how did you come across these signatures?
So it was in the materials that Mr. Renard, the insurance investigator, reviewed.
And if I could direct you to page 40 of the trial packet, and let me know when you're there.
Sorry.
No worries.
Okay.
What are you looking at, Ms. Pride?
So this is, hold on, I thought I was on page 40, my mistake. Okay, this is the signature comparison that Mr. Renard did.
And is it in the same condition that it was when you looked at it during your investigation?
It is, yes.
Your Honor, at this time, plaintiff moves what's been previously marked 007 into evidence as Exhibit 4.
Any objection to exhibit 4?
No objection.
All right, exhibit 4 shall be admitted.
Now, I'd like to turn to these samples that you analyzed. May I share my screen, Your Honor, with a demonstrative?
You may.
Ms. Pride, would you mind sharing with us some observations that you made about the sample signatures that you analyzed?
Yes, so the next step in my process was looking at the different samples and looking for handwriting characteristics in them. Those characteristics are shapes, angles, letter height, that sort of thing. So the first thing that I noticed in looking at the samples and looking for those characteristics was the O.
What did you notice about this O?
Of course, so as you can see in these examples, is that there's only one loop in the interior of the O. The other piece of this is that this is what we call a lazy letter. It's basically something that explains that it's not clearly written, and it's usually found towards the end of a signature. Finally, you can also see that the writer for both of those signatures rarely lifted their pen.
In your opinion, Ms. Pride, were these two sample signatures signed by the same person?
In the driver's license and the restraining order, yes, they were signed by the same person.
Now, let's move on to the will signature. In your opinion, was this signature signed by the same person who signed those two samples?
No.
Why not?
There were some very major differences between the signatures.
What was the first difference?
Of course, so that first big difference was the D in Donaldson. As you can see in the two samples provided, the driver's license and the restraining order, you can see that the pin lifts almost for just a split second. And then looking at the D that was on the last will and testament, you can see that there are two distinct pin strokes to that.
And what was the second observation you made between the differences?
The second observation, again, involves that O that I talked about earlier. All right, so as you can see, again, we have the lazy O that's in those two original samples, whereas in the last will and testament, there's that full O.
And did you have any final observations about the will signature?
Yes, so one of the things that you can see when looking at the entirety of that signature is that it's very shaky. There are quivering lines throughout it, suggesting that the signature that the writer produced, the writer was very nervous and writing slowly when producing that signature. You can commonly see that when someone is attempting a forgery.
So in light of all of this, what's your ultimate conclusion regarding the signature on the will?
So given those inconsistencies between the samples of Lou Donaldson's handwriting and the signature provided in the last will and testament, it is my professional opinion that the signature on the last will and testament is a forgery.
Now, Ms. Pratt, I'd like to just conclude with a quick discussion of the defense's Costa Rica theory that Lou Donaldson vanished, never to be seen again, to Costa Rica. Did you look into this theory?
I did.
And what do you make of this theory?
I did not believe that theory to hold any sort of water.
And why not?
Well, I was able to actually send one of my employees down to Costa Rica to actually search for Mr. Donaldson there.
And what did she find?
Well, she found what basically has been the status quo. No one has seen Mr. Donaldson in Costa Rica, including that employee. She looked all over and she could not find a trace of evidence that Mr. Donaldson had stepped foot in Costa Rica back in August of 2012 or at any time since.
So given all of this, what we've talked about, Ms. Pride, the will, the circumstances, what is your ultimate conclusion in this case?
Yes, it is my professional opinion that Karen Baggia was responsible for the death of Mr. Donaldson and that the will produced by Ms. Baggia was forged.
Thank you, Ms. Pride. No further questions.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Now, there's been a lot of talk about the restraining order, and I want to clear that up. That restraining order was ultimately denied.
It was, yes.
Now, I want to talk to you about your credentials. You don't have a PhD.
No, I do not.
You don't have a master's degree.
No,
You don't have a bachelor's degree.
no,
You're merely board certified.
that's correct.
And outside of that board certification, you hold no other specialized degrees.
No, sir.
And that board certification took just 2 weeks to get when you originally got it,
Yes, it was a pretty intensive 2-week course.
but it was just 2 weeks.
Yes, that is the time the course took.
Now, I want to talk to you about your conclusion in today's case. You claim that Karen Beja likely forged the will,
Yes, that is my conclusion.
but you would agree with me that no two signatures are ever exactly the same.
That's correct.
There are reasons why a signature could differ.
Exactly. And looking at the two samples provided, you can see there's some minor differences. So yes, there are reasons.
And in fact, there were similarities amongst those signatures that you found.
Correct.
And if someone were in a rush, their signatures would be different.
In theory, yes.
If someone had a motor function illness, their signatures might even differ.
If that was a factor, yes, it could influence the signature.
Now, I want to talk to you about Mr. Donaldson. You were aware that he often flew planes.
Yes, I was aware of that.
And when he flew planes, he would sometimes not log a flight plan.
Yes, that is correct.
That means it would be rather difficult to find someone.
I wouldn't necessarily say that.
It wouldn't be difficult to find someone if they didn't log a flight plan.
He could have mentioned the flight plan to someone else. I don't think those necessarily go hand in hand.
So you don't believe it to be a factor if someone didn't log a flight plan?
I'm sorry, I don't think I got the full part of your question.
It would be challenging to find someone if they didn't log a flight plan,
It could add challenges, but it would not be impossible.
but it would be challenging.
Yes, it would add challenges.
Now, you reviewed the Pioneer County Sheriff's Office report before today's case,
I did, yes.
and they concluded that there was likely no foul play involved.
Yes, and that's a conclusion I disagreed with.
And you also reviewed Chris Renard's report before today's case.
That is correct.
And you were aware that he works for Summit Life Insurance Company.
Yes,
And part of his job is to find any grounds to contest payments.
that is correct. I believe that's part of his job.
But Chris Renard found no grounds.
That is part of his findings, yes.
Thank you. No further questions.
All right, thank you. Any redirect?
Not at this time, Your Honor.
All right, are there any additional witnesses from the plaintiff?
No additional live witnesses, Your Honor, but plaintiff would like to enter a portion of Carl Bannister's deposition pursuant to stipulation number 4 of the parties.
And it is my understanding that this witness is stipulated. Are there any objections to pieces of the testimony, though, that we need to handle, or have you guys reviewed that testimony in advance?
We have not shared the portion that we plan to read with the defense, but
Okay. If there's any objections to any pieces of that testimony, we can just address it as we normally would with a live witness. So whenever you're ready.
Your Honor, if I may, I would object. The stipulation is to 804A that the witness is unavailable, but this document is still an out-of-court statement being used for the truth of the matter asserted. The stipulation is not to one of the 804 exceptions. It's only to 804A. So we object on hearsay grounds.
I think this witness is stipulated as admissible as an unavailable witness. So I'm going to allow this for you to read in whatever portion of Mr. Bannister's testimony you want. Certainly if there's objectionable testimony that is being read in, you can raise your objection. So, but it's my understanding that this witness is agreed upon and stipulated that they are unavailable. So whenever you're ready, Ms. Morris.
yes, Your Honor. And just for the clarification for the court, I will read the question and my co-counsel will read the answer as Officer Bannister.
Great, thank you.
Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m., as it was showing it was near the grocery store close to Ms. Baj's home during that time?
Answer. Yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was replaced the next day.
That concludes the portion that we wish to enter, Your Honor.
All right, Mr. Jefferson, do you have any cross-examination pieces of this witness that you'd like to read in?
No, Your Honor.
Okay. Plaintiff, do you have any additional witnesses?
No, Your Honor.
All right. At this point, we're going to take just a brief recess, bathroom break, whatever you all need. We're going to come back in about.
Your Honor, before we take a recess, defense would like to make a motion as a judgment matter of law.
Okay, we can do that now. Whenever you're ready, you can make your record.
Yes, Your Honor. Defense moves for a judgment as a matter of law pursuant to Rule 50 of the Rules of Civil Procedure. May I be heard?
You may.
Even when you view the facts in the light most favorable to the non-moving party, a reasonable juror would not be able to find that Karen Beja is liable for the wrongful death of Lou Donaldson. In order for the non-moving party to meet their charge in today's case, they had to prove to you 4 elements, but we mainly contest the first 2, is that Mr. Donaldson is dead. They've offered no theory to Mr. Donaldson's cause of death. They've offered no date, no time, We've heard nothing about DNA, if there's any blood residue, hair follicles, skin cells. They've offered no theory. They don't have a body. There's no autopsy report. At best, they just want you to speculate because he hasn't used his bank account. That doesn't meet under a preponderance of the evidence that Mr. Donaldson is dead. In addition, they haven't proved that Karen was the individual that did it. There's no testimony that anyone saw her, no bloody knife, there's no murder weapon. There's nothing to suggest whatsoever that Karen Beja murdered Lou Donaldson. And because of that, even when you view the facts in the light most favorable to the non-moving party, a reasonable juror would not be able to find Karen Beja liable.
All right, thank you. Response from the defense?
From the plaintiff, Your Honor?
Yeah, sorry, thank you.
Yes, Your Honor. We have in fact proven all 4 elements of wrongful death in today's case. The jury heard from Cam Donaldson, who told the jury about how his father requested a restraining order and feared for his life. Cam Donaldson told the jury about how Karen Beja threatened to kill Lou Donaldson on multiple occasions. Cam Donaldson told the jury about how she stole the will from his lockbox that divided the assets up 4 ways and replaced it with a forged will that gave everything to her, which provides motive for why she would want to murder him. We also heard from an expert, Taylor Pride. Taylor Pride gave in-depth evidence about how the will was forged and showed signature comparisons to further evidence that. Taylor Pride also gave evidence as to the fact that Lou Donaldson is dead. She is a private investigator and showed that she investigated Lou Donaldson's death. She sent employees to Costa Rica to investigate whether or not he was currently living there and was unable to find anything. So we have proven that Lou Donaldson is dead and that Karen Beja caused his death. Circumstantial evidence is still evidence.
All right, thank you. When the court is tasked with ruling on a halftime motion under Rule 50, the court must view the light most favorable to the non-moving party, which would be the plaintiff. Based on the evidence I've heard, I think that there is sufficient evidence to send this to the jury or at least go to the second half of this case. So I'm going to deny the Rule 50 motion. We will take a brief break. 10 minutes, is that enough for everyone? Okay, so we will come back and start right at 7:40. So take your 10 minutes and we'll see you back for the defense case in chief. All right, we are back on the record for the second half of the Summit Cup case. Are the parties ready to proceed with the defense case in chief?
Yes, Your Honor.
Defense, are you ready?
Yes, Your Honor.
Okay, great. Would you like to call your first witness?
Yes, Your Honor. The defense would like to call Miss Karen Beja to the stand.
Okay. Ms. Beja, just remind you you're under oath and the well is yours, Mr. Jefferson.
Thank you, Your Honor. Please state your name, spelling your last for the record.
I'm Karen Beja. That's Basia.
And what is it that you do for a living, Miss Beja?
Well, I run Wild Wildlife. It's a sanctuary for big tigers, lions, leopards, mostly tigers. We rescue and preserve these beautiful, majestic animals.
Now I want to talk about Lou. Can you tell us a little bit about Lou?
Lou was my husband for over a decade, and we loved each other so much. Yes. And I would really call him my soulmate. I really would.
And what did Lou do for a living?
Well, he ran Wild Wildlife, but before that, he had made so much money working as a used car salesman. Yeah, he'd really made a fortune.
And has Lou been successful in his business ventures?
Oh yes, he was known as the Green Thumb because he could just make money doing anything. He was such an entrepreneur.
Now I want to talk about your marriage to Lou. Can you tell us a little bit about your marriage to Lou?
Right. Well, as I said, we were married for over 10 years, and everything started off wonderful. Things were really great for a really long time. Eventually, we had a few problems, but what marriage doesn't. I found out he was seeing someone else, and that was pretty heartbreaking.
Objection, hearsay.
I think one of your witnesses actually testified that he was having an affair. So I think this is the cat's out of the bag at this point, but I'll let Mr. Jefferson respond to hearsay.
Yes, Your Honor. This is not hearsay, Your Honor. It's not being offered for the truth of the matter asserted, Your Honor. It's being offered to show that Lou potentially may have had someone in Costa Rica and therefore would have had a reason to travel there, and goes towards the defense's case, the defense's theory in this case. And as you stated, Your Honor, this has already been put out, Your Honor.
All right, overruled.
Yes, Your Honor.
Miss Beja, did you know who this person was that Lou was seeing?
No, she was a mistress in Costa Rica. I never spoke to her. I never met her.
I want to talk about Lou's travels to Costa Rica. Did Lou travel to Costa Rica?
Yes, he did. Sometimes on business, sometimes for other things.
And how would Lou get to Costa Rica and back?
He was a private pilot, so he flew his own planes there and back.
And would Lou do this frequently?
Yes. I mean, I couldn't tell you the number of times that he did. He was jetting off all over the place on not a regular basis, but frequently.
Do you know how many planes Lou owned?
No, I don't know that anyone did except for Lou. He would buy and sell them, and often without even registering them. So I don't know that anyone knew besides himself.
Now, would Lou try to hide these flights in any way?
Yes, his pilot's license was actually suspended. So he stopped logging his flights and became pretty secretive about it, not really always telling people that he was going or where he was going.
Improper character evidence.
Response to improper character evidence?
Again, Your Honor, similar to the objection made earlier on a similar improper character evidence opinion, I believe it was on the suspension of Lou's license. The fact that Lou may have tried to hide these flights in certain ways makes it more likely that it doesn't go to a character inference. It goes that he would have been able to hide these flights and make it so that he could go to Costa Rica undetected.
May I respond?
You may.
Your Honor, my objection this time wasn't to the fact that Lou Donaldson had a suspended pilot's license, but rather to the fact that Lou Donaldson was secretive. That absolutely is a character trait.
Okay, what's your response to the secretive piece?
Your Honor, we can move to strike that.
Okay, yeah, I don't think that's even the point of the testimony. So I think that's sort of irrelevant to both sides. So we'll strike that piece on the secretive notion and move on.
Yes, Your Honor.
Just to clarify, Your Honor, the rest of the answer is still on the record.
Correct.
Now, Ms. Beja, were you at least always aware of Lou's trips?
No, he didn't always tell me where he was going or that he was going. No, he'd just up and leave. And I didn't know that he'd be gone or when he'd get back or what he was leaving for.
And now I want to talk about the night Lou was last seen. Do you remember where you were on the evening of August 17th, 2012, and into the morning of August 18th, 2012?
Yes. So at the Tiger Sanctuary, there had just been a new litter of cubs born a few days before, but their mother had basically abandoned them. She was not taking care of them. So I took that upon myself to take care of these newborn tiger cubs. And on that night, really early in the morning, I realized we were completely out of milk and formula, and these little cubs, newborns, were so hungry, I had to go to the store in the middle of the night, go buy milk and formula. So that's what I did.
And about what time did you run to the store?
It was about 3 a.m.
And what happened when you left the store?
Well, of course, Murphy's Law, my car broke down. So I had to get help.
What did you do when your car broke down?
Well, I did manage to pull my car over to the side of the road, and I flagged down another driver, and the gentleman lent me his cell phone. I called my brother to come get me, and he came, got me home with the milk and formula for the cubs.
Now, you mentioned that you borrowed the gentleman's cell phone. Did you not have your cell phone on you?
No, I guess not. I mean, it was 3 a.m. I had been taking care of these cubs all day. They were my priority, and I was tired. So I must have just left my cell phone there in my rush to get to the store.
And you also mentioned that you chose to call your brother. Why did you choose to call your brother and not your husband?
Right. So as I said earlier, I didn't know for sure whether or not Lou would even be home, but my brother is a sheriff's deputy and his job is to help people. And I knew that he would be around and he would be able to help me. And that would be the fastest way that I could get home to the cubs.
And what made you believe that your husband may not have been home?
As I said, he would take flights without telling me. So I imagined that that could be what he was doing.
No further questions, Your Honor.
All right, thank you. And just before we move to cross-examination, I apologize. I didn't check to make sure everyone saw Alex's note. The witness, Taylor Pride, she was keeping time. It looks like the plaintiff has used 40:37, leaving about 29 minutes. Defense at that time, at halftime, you had used 11:48. I imagine it's slightly longer now. You have 58 minutes. Did everyone see that note from her? Okay. And that's, everyone sort of has the same time. No issues with that? Okay, great. Sorry, I just realized I didn't alert you to that little comment earlier. So cross-examination when you're ready.
Now, on direct, Ms. Baja, you mentioned that you thought your husband had a mistress in Costa Rica. Is that correct?
Yes.
But to be clear, you've never seen text messages between your husband and this alleged mistress, have you?
I have no knowledge of any text messages.
You've never seen emails between them?
No.
You never overheard phone calls between them?
No, not that I could say.
You never saw her phone number in his call history?
No.
So you don't have any physical evidence whatsoever of this alleged mistress?
No, I suppose not.
Now, I'd like to talk about the last time you saw your husband alive. The last time you saw him was August 17th, 2012, right?
Yeah, probably.
And he hasn't contacted you since that day?
No.
And no one else has told you that he's contacted them since that day?
No, not since that day.
So to the best of your knowledge, Lou Donaldson hasn't been seen or heard from by anyone since August 17th, 2012.
Yeah, that's right.
Now, I'd like to talk about where you were on August 17th, 2012. You testified on direct that that night you were taking care of some tiger cubs.
Yes, I was.
And in the middle of the night, around 3 a.m., you realized you were out of milk.
Yes, I did, and they needed it.
So you went to the store.
Yes, I did.
And on the way home, your car broke down.
Yes.
Now, Miss Baja, you loved your husband, didn't you?
Yes, with all my heart. As I said, soulmates.
And during the course of your marriage, you had each helped each other.
Sure, yeah.
So you'd feel comfortable going to him for help if you needed it.
Yeah, if I thought he could help.
So that night, naturally, you called your husband when you were stuck on the side of the road.
No, I didn't.
Right, you called your brother instead.
Right, because as I said, I knew my brother would be able to help that day, and I didn't know if my husband would be able to.
You didn't call your husband to see what he was doing.
No, I mean, no, I didn't.
You just assumed he wouldn't be available.
Yeah, but I knew my brother definitely would be, and that was my fastest route back to the Cubs.
So when your brother dropped you off at home, the first thing you did was to wake up your husband and let him know what had happened.
No, my first thing was to get the milk and formula for the Cubs.
Right, you didn't even check to see if your husband was at home in bed.
That wasn't my priority right then, no.
You just assumed he wasn't there.
I was focused on those newborn Cubs.
So you assumed your husband wasn't at home.
I suppose, yes.
Now, finally, Ms. Baja, I'd like to ask you about the meat grinder at Wild Wildlife. You do have a meat grinder on property, don't you?
Yeah, we have a meat grinder.
And you keep that meat grinder because you have a lot of big cats.
Yes,
And those cats eat meat.
of course, carnivores.
They eat a lot of meat.
Yeah, they do.
So you use that meat grinder fairly frequently,
I suppose.
and you're familiar with it.
Yeah.
Objection, Your Honor, cumulative.
Overruled.
You're familiar with that meat grinder,
Sure, yes.
and you know that it takes at least 2 people to operate.
Yeah, it's really big.
But in your opinion, as long as there are 2 people present, it's large enough to use to dispose of a body.
I mean, yes, it's large enough, but that's insane.
So that's a yes to my question. It is large enough to dispose of a human body.
Yeah, I already said yes.
Thank you, Ms. Baja. Your Honor, I have no further questions at this time.
All right, any redirect?
Yes, Your Honor, briefly.
Okay.
Ms. Beja, when you were stuck on the side of the road, what was your primary concern at that point?
My concern was getting back to those newborn cats because they needed me and they needed the milk and formula that I had gone out to go buy.
No further questions, Your Honor.
All right, thank you. May this witness step down. All right, you're free to go. Thank you so much for your time. Would the defense like to present any additional witnesses?
Yes, Your Honor. At this time, the defense calls Chris Renard to the stand.
All right. Mr. Renard, I just remind you that you're sworn in, and the well is yours, Mr. Aguiar. Am I saying your last name correctly?
Aguiar, Your Honor.
Aguiar, thank you.
Please introduce yourself to the members of the jury.
Good afternoon. My name is Chris Renard. That's Renard.
Mr. Renard, what do you do for a living?
Well, I'm an investigator and forensic document examiner for Summit Life Insurance Company, specializing in handwriting and signature identification.
How long have you had this position for?
Oh, I've done this 20th year with the company since the year 2000.
Did you work anywhere prior?
I did. I graduated from the Stateville Police Academy in 1997. I was with them for a year.
And what position did you have with the academy?
With the academy, I went with them after I got my BA in criminology at Summit College in 1996. Yeah.
In those 20 plus years of experience, roughly how many documents have you reviewed?
Oh, hundreds of documents over those years. I can't even put a number on it.
When you looked at those documents, what did you do?
Well, I investigate them. I review many documents such as wills. I make sure there's no foul play involved in the decedent's death. I ensure the will is legitimate, and I see if there are any grounds to contest payment for life insurance policies.
In your 20 plus years while working in the field, have you ever testified in court before?
Yes, I've testified over about 25 times for the prosecution, and I think this is my 24th time for Summit Life Insurance.
Did the court accept you as an expert in those 25 cases?
Yes, actually, I was accepted as an expert in all of them.
Now, earlier you mentioned that you would deal with handwriting analysis. How do you go about doing that?
Well, with handwriting analysis, you analyze the patterns themselves. You look at the consistencies in the signatures, and then you determine if the signature was forged or not.
Your Honor, at this time, defense moves to tender Chris Renard as an expert in forensic document examination.
Any objection or voir dire?
No objection or voir dire, Your Honor.
All right, this witness will be tendered as an expert in forensic document examination.
Mr. Renard, how are you involved in today's case?
In today's case, I was asked to review Mr. Donaldson's will and see if there are any grounds to contest the payment for the life insurance policy.
How did you go about finding any grounds to contest the life insurance policy?
Well, primarily I relied on 3 documents. The first was a life insurance company paperwork document. The second was Mr. Donaldson's driver's license. And the third was Mr. Donaldson's last will and testament.
Well, let's take a step back. Why did you rely on those 3 specific documents?
Well, those 3 specific documents had Mr. Donaldson's signature on them, and I needed multiple signatures in order to compare the signature and ensure that no document was forged.
You mentioned that you compared the signatures. Was there a specific method that you used?
Yes, there was actually. It's a method commonly referred to simply as comparative analysis.
What does a comparative analysis entail?
Okay, so I line the 3 signatures together to examine them for any similarities or for any differences. I look to see whether the individual lifts up their pen at certain points during their signatures or any loops on certain letters. I also look at the size, the shape, slant, beginning and the ending stroke of the letters.
Did you follow that standard in today's case?
Yes, I did.
Is that standard accepted in your field?
Yes, it is.
When you compared Mr. Donaldson's signatures using that comparative analysis method, what did you find, if anything at all?
Well, what I found is that there were sufficient similarities in all 3 of Mr. Donaldson's signatures.
What were those sufficient similarities?
They included similarities in the loops, similarities in the stroke direction, curves, legibility, angles, embellishment, as well as capitalization.
Did you find any discrepancies at all?
I mean, there were some, however, those discrepancies, they were inconclusive at best.
What do you mean by that?
Well, it means simply that it's unlikely that someone tried to copy Mr. Donaldson's signature.
Did you come to any conclusion in today's case?
Yes, I certainly did. I do not believe Summit Life Insurance has any grounds to contest a life insurance policy based on Ms. Basha's forging Mr. Donaldson's signature. And my professional recommendation here today is to pay the proceeds of Mr. Donaldson's life insurance policy.
Thank you. No further questions.
All right, thank you. Cross-examination.
Mr. Renard, I'd like to talk about some portions of the report that you prepared for Summit Life.
Okay.
You wrote in your report that you, and I quote, gleaned that the sheriff's office tested Ms. Baja's meat grinder because if they had, they would have found bodily evidence.
Objection, Your Honor, to hearsay, if I may be heard.
You may.
Counsel's question specifically stated in your report, and that's the case. If the fact by phrasing it that way, it's having this witness rely on an out-of-court statement that's being used to prove the truth of the matter asserted.
Overruled.
May I repeat the question, Your Honor?
You may.
In your report, you wrote that you gleaned that the sheriff's office tested Ms. Baja's meat grinder.
Yes.
Correct? But you don't actually know whether they tested that meat grinder, do you?
That's just my observation and professional opinion.
It's your opinion that they tested the meat grinder, though you wrote that you simply gleaned it.
Yep, I simply gleaned it. I don't know for sure.
So you know that this investigation is an ongoing, active investigation.
Yes.
And that means that you're not entitled to certain portions of confidential information regarding this investigation.
I suppose I'm probably not.
So when you wrote in your report that they tested the meat grinder, that you gleaned that they tested the meat grinder, you didn't include any test results of this test.
Nope, I included everything in my report that I know about the meat grinder.
And you didn't include any conversation with any officer who tested the meat grinder.
No, not any specific officer, no.
And multiple conclusions relied upon your contacts with the sheriff's office, but you never listed any of those contacts, did you?
I wanted to keep them somewhat anonymous just so I can preserve them for the future.
So because you don't know whether they tested this meat grinder, you actually don't know whether they found any DNA evidence or not.
Yes, that's correct.
I'd like to now move on to the will that you analyzed, specifically the signature at the bottom.
Okay.
You wrote in your report that there were differences between the will signature and the sample signatures.
Yes, there were small, minute differences.
In your report, you wrote that they were differences.
Yes.
And in fact, in your report, you wrote that you could not determine whether the signature was genuine or not genuine. Is that right?
I concluded it was highly probable that it was genuine.
But in your signature comparison, you did write that you couldn't confirm whether it was genuine or non-genuine?
I couldn't confirm 100%, no.
This was a report that you prepared for the CEO of your company, correct?
Yes, the CEO of Summit Life Insurance.
About Lou Donaldson's life insurance policy.
Yes.
his $5 million life insurance policy?
Yes.
So, Mr. Renard, in the report that you prepared for the CEO of your company about a $5 million life insurance policy, you could not confirm with certainty that the signature on the will was genuine?
Well, in this particular field, you can't confirm with 100% certainty any of the time. And all I did was the work that I've done for my CEO countless times before.
But in your report, again, yes or no, you could not confirm that the signature was genuine or non-genuine.
With 100% certainty, no, I could not.
Now, finally, I'd just like to confirm some dates that you discussed in your report.
Okay.
Lou Donaldson was last seen on August 17th, 2012, correct?
Yes, that is correct.
And Ms. Baja reported him legally dead on August 18th, 2017.
That is correct, yes.
And that's the same day that she collected the life insurance policy, correct?
Yes.
And this was 5 years to the day that Lou Donaldson had gone missing?
Yes.
And to confirm, this was the first day that Ms. Baja was legally allowed to collect Lou Donaldson's life insurance policy.
Objection asked and answered, Your Honor. She's already asked this question.
Overruled.
May I ask the question again, Your Honor?
You may.
This was the first day that Ms. Baja was legally permitted to collect Lou Donaldson's life insurance policy.
Yes, it was.
Thank you. No further questions.
Thank you. Redirect.
Yes, Your Honor. Mr. Renard, just to clarify, was there any DNA evidence found on the meat grinder?
In the meat grinder, there was no trace of human DNA or blood.
Thank you.
Objection, Your Honor. That calls for hearsay?
Overruled.
I'll re-ask the question. To clarify, was there any DNA evidence found on the meat grinder?
No, there was no DNA evidence found on the meat grinder.
No further questions, Your Honor.
Thank you. Does the defense have any additional witnesses?
No, Your Honor. However, at this time, the defense would like to make a motion for judgment as a matter of law when you're ready to hear it.
Sure. Go ahead. I'm ready now.
Your Honor, the defense moves for judgment as a matter of law. Your Honor, the plaintiffs had to prove two primary elements in today's case. They had to prove that Lou is actually dead and that Karen is the one who actually killed Lou. To this point, Your Honor, the plaintiffs have still not presented evidence of a body, of a weapon, and the only theory that the plaintiffs have pointed out is that there was a meat grinder, which we just heard that there was no DNA evidence found on, Your Honor. Therefore, the plaintiffs have not proven their case by a preponderance of the evidence. To the contrary, Your Honor, we have seen evidence that it's possible that Lou was not dead. We've heard testimony that he had a mistress in Costa Rica, that he would travel and fly to Costa Rica. Your Honor, it is plausible that it is likely that Mr. Donaldson is still alive down in Costa Rica, and the plaintiffs have not proven that he is dead or that Karen is the one who actually killed Lou, Your Honor. So therefore, the defense moves for judgment as a matter of law.
All right. Response to the defense's motion.
Your Honor, pursuant to your prior ruling at the end of plaintiff's case in chief, plaintiff would request that you send the case to the jury after closing arguments. In addition to all the evidence that we heard prior to the defense's last motion for judgment as a matter of law, we have additionally heard evidence from the defendant herself about how she had access to a meat grinder, was familiar with how to use it, and it was large enough, in her opinion, to dispose of a body. We also heard from the defense's expert, Chris Renard, the insurance agent, about how the insurance company had enough information to declare Lou Donaldson dead, and how he believes that the will could have been forged, which further goes to Karen Baja's motive to kill her husband.
All right. Thank you. I'm going to stand by my initial ruling. We will submit this to the jury once we've heard closing arguments. Do we need a brief time check before we go into closing?
And Your Honor, we're just calculating the remaining time. So if we could just have a moment to finish those calculations, we can give that time check.
Okay, great. Thank you. Do the parties need any break before we go into closing?
No, Your Honor.
Okay. Great. So while they're calculating time, plaintiff, you can get ready to proceed with your opening if you need a moment to prepare your well or get any exhibits organized to share the screen. And as soon as we get that time check, we'll send you into closing. I think both parties are probably, both sides are probably just fine on time. The second half of the case went much faster.
Yes, Your Honor, looking at the time checks, and this is still just rough, both sides are well under the 70-minute mark.
Okay, great. That's fine by me. Alex, if you want to just throw in the chat once you have that formulated, and if you can just let me know if they go over while it's happening. I cannot imagine that's going to happen. Do we need to reserve any time for rebuttal closing for the plaintiff?
Yes, Your Honor, if I may.
Okay. Do you want any warning or heads up if you like when you're at if you get to 5 minutes left?
Could I get a warning at 1 minute?
Sure. What I'll do is if you get close to that, Alex, if you'll just throw it in the chat and then I'll just raise my hand for you, Ms. DeMeglio. I'll be off screen. I'll jump back on basically and give you the heads up if you're getting close to that, but I don't imagine that either team is going to have issues with timing. So okay, there we go. Plaintiffs have 20 minutes remaining, so you should be just fine on time. But we'll certainly let you know if you run close.
May I proceed?
You may.
We're here today because of three things: motive, murder, and mourning. Karen Baja and Lou Donaldson's marriage was tumultuous. Lou Donaldson told Karen Baja that he wanted a divorce. This, combined with her desire to control her husband's massive fortune and collect on his life insurance policy, became the defendant's motive to kill her husband. On August 17, 2012, Karen Baja murdered Lou Donaldson. With the help of her brother, Officer Carl Bannister, she disposed of his body in a meat grinder and presumably fed the remains to her tigers. That was the last day that Cam Donaldson saw his beloved and devoted father. Since then, Cam Donaldson has missed his father every day. He's been in a state of mourning. He'll never get another piece of advice or hear another dad joke. When someone steals something from you, they must be held accountable. Karen Baja stole everything from Cam Donaldson. Members of the jury, only you can hold her accountable today. Now, in order for you to find Ms. Baja legally accountable, there are some things that you must find that we, the plaintiff, have proven by a preponderance of the evidence. Now, all this means is that you must find that we've proven that certain facts are more likely true than not. Now, it's important to keep in mind that you don't have to be 100% sure you know what happened to Lou Donaldson. You don't even have to be 60% sure you know what happened. Under the law, a feather on the scales that tips the balance in our favor, even slightly, is enough for you to find Karen Baja liable. Now, in a few minutes, at the conclusion of today's trial, the judge is going to give you 4 elements. And you must decide whether we've proven that those elements are more likely true than false. If you find that all 4 are more likely than not true, then you must return a verdict in favor of Cam Donaldson. Those 4 elements are: first, that Lou Donaldson is dead; second, that Lou Donaldson's death was caused by Karen Baja's intentional or reckless conduct. Third, that Cam Donaldson suffered injuries, damages, or losses because of Lou Donaldson's death. And fourth, that Cam Donaldson's injuries or damages were caused by Karen Baja's conduct. Let's break those elements down, and we'll walk through them together. I'd like to start with the first two, that Lou Donaldson is dead, and that his death was caused by Karen Baja's intentional or reckless conduct. To prove those elements, let's talk about why Karen Baja had a motive to murder Lou Donaldson. In fact, as you heard today, the defendant had more than one motive. Karen Baja's first motive to kill her husband was her relationship with him. As you heard, Lou Donaldson was ready to get divorced. But members of the jury, the defendant couldn't handle that. Cam Donaldson sat on the stand and told you how as soon as his father brought up the word divorce, Karen Baja screamed, "I will kill you." Cam Donaldson told you how scared his father looked when he heard the defendant's threat, and how he instructed Cam to have the police look into Karen if anything ever happened to him. Lou Donaldson feared for his life and sought a restraining order to protect himself. But as you heard, the court failed to grant that restraining order. And rather than wait for her husband to proceed with the divorce, Karen Baja killed him. Which brings me to the defendant's second motive for murder: greed. Members of the jury, you heard how Cam Donaldson was next in line to take over the family business. But Karen Baja didn't want Cam to take the family business. She wanted it for herself. Karen Baja sat on that stand and told you today that she loved those tigers. They were her whole world. And members of the jury, we aren't contesting that. We know that Karen Baja loved those cats. She loved them so much that she would do anything to keep them for herself. You heard how Taylor Pride, an expert in investigating forgeries, compared the evidence of previous signatures to the signature on Lou Donaldson's will. You saw for yourself how those signatures, well, they were vastly different. You also heard how the will contained the phrase, "if I should die or disappear." Now, witness after witness told you that they had never seen that in a real will before. This will only contained it because it was forged by the defendant after she faked Lou Donaldson's disappearance. You heard how just 2 days after Lou Donaldson disappeared, the defendant cut the lock on the office at Wild Wild Life so she could access her husband's last will and testament. So members of the jury, remember, no one thought Lou Donaldson was dead at that point. Why would the defendant need to access her husband's will if she thought he was alive and on a business trip somewhere? That's because she knew something nobody else did, that he was already dead. Karen Baja forged Lou Donaldson's will so that she would collect all of his assets, including the cat sanctuary. These motives led the defendant to murder Lou Donaldson. Now, it's undisputed that no one has seen or heard from Lou Donaldson since August 17th, 2012. You saw Lou Donaldson's bank records. You saw how he didn't spend a cent after that day. You heard from several witnesses how the probate court of Statesville declared Lou Donaldson dead 5 years after his disappearance in August 2017. But the court didn't declare Lou Donaldson dead on its own. Lou Donaldson was declared dead because the defendant herself requested it at the first possible moment the law allowed her to do so. Now, the defense has tried to tell you a story about how Lou Donaldson is alive and living in Costa Rica. But ask yourself, is that realistic? You heard how Lou Donaldson left behind his only pair of glasses. And Cam Donaldson told you that his father was blind as a bat without them. Is it realistic that he supposedly flew over 2,200 miles alone without being able to see at all? The defense's own expert, insurance agent Chris Renard, told you that he believes Lou Donaldson is dead. The insurance company, who would rather find some indication that Lou Donaldson is alive so they could avoid paying on that $5 million policy, even found that Lou Donaldson was dead. Let's talk about the night that Karen Baja actually murdered Lou Donaldson. She told you that between August 17th and 18th, she was taking care of some tiger cubs. And in the middle of the night, she ran out of milk and had to go to the store. But recall, you saw Lou Donaldson's bank statement. You saw that his last purchase on that very same day was for $940 worth of animal supplies. Do you really think that less than 24 hours after her husband had spent almost $1,000, Karen Baja was already out of milk? Did the defense show you a receipt for the milk Karen Baja supposedly bought that night? They didn't, because they couldn't. Karen Baja wasn't at the store that night. This was her cover story, so that she could meet her brother, Officer Carl Bannister. Now, you may be thinking to yourself, why would Karen Baja need to meet up with her brother? But the defendant answered that question for you herself. She sat right there on that stand and told you that she could have used the meat grinder at Wild Wildlife to dispose of a body if she had a second person there to help her. And that second person was her brother, Officer Carl Bannister. The defendant knew that he was a deputy sheriff, and the two of them, they were close. You heard how the records for Officer Bannister's patrol vehicle show that it wasn't moving between 3:20 a.m. and 6:30 a.m. that morning. It wasn't moving because he was with the defendant, helping her dispose of Lou Donaldson's body. Now, the defense tried to tell you that Officer Bannister was just being a good brother, just dropping Karen Baja off at home after she called. But ask yourself, wouldn't you expect someone to call their spouse when they needed help in the middle of the night? Wouldn't you expect someone to at least pick up the phone and see if their spouse could help them? At the very least, wouldn't you expect someone to wake up their husband and let them know what had happened? Let them know the car was sitting on the side of the road somewhere? Karen Baja didn't do that because she couldn't. Lou Donaldson was already dead, and she needed someone's help to dispose of his body. The defense also tried to tell you that the meat grinder had never been used to dispose of a body. The defense's expert witness told you that the meat grinder had been tested and that nothing was found. But think about that. If the defendant's brother, a police officer, had helped her with the crime, would his friends on the police force really be interested in investigating it? Did you see a police report about how the police tested the meat grinder and found nothing? Did you hear today from a police officer who told you that they tested the meat grinder? You haven't seen any evidence that the meat grinder was tested because it wasn't. All you have is the defendant's word and the defense expert's assumption. Members of the jury, it is more likely than not that Lou Donaldson is dead and that Karen Baja intentionally killed him. father was brutally murdered by Karen Baja, Cam Donaldson has been in a state of mourning. Which brings me to the last two elements. That Cam Donaldson suffered injuries, damages, or losses because of his father's death, and that Karen Baja's conduct was the cause of those losses. Now, these two elements are undeniable. Cam Donaldson told you how much he loved his father, how much he still misses him. Cam Donaldson told you that because the defendant forged his father's will, he will no longer have the opportunity to work at or run the business that his father built for him. Clearly, Cam Donaldson has suffered losses because of his father's death, and because Karen Baja intentionally killed Lou Donaldson, her conduct caused those losses. Now, after you decide whether the defendant is liable for wrongfully killing Lou Donaldson, you have to decide whether to award damages to Cam Donaldson to compensate him for what he lost. Now, we all know that no one can put a price on what it means to lose a parent, but there are a few concrete numbers we can point to illustrate what Karen Baja took from Cam Donaldson. First, Mr. Donaldson is owed the proceeds from the life insurance policy in the amount of $5 million. Karen Baja wrongfully received that money and should not be allowed to profit off of murdering her husband. Cam Donaldson is also owed the deed and ownership to Wild Wildlife, which is valued at $5 million. Cam Donaldson told you that he was next in line to run that business. And because Karen Baja forged the will, she not only took that business, but she took from Cam the opportunity to run that business together with his dad. Which brings me to non-economic damages. Under state law, you have the power to award Cam Donaldson non-economic damages to compensate him for his pain and suffering, emotional stress, and loss of companionship that he suffered when his father was killed. Cam Donaldson will never spend another day with his father. As you think about how much that might be worth, consider, how much would a son pay to spend just one more day with his dad? Multiply that by a week, a month, a year, 30 years. Members of the jury, we know that that number is infinitely large. But today, we're requesting $25 million to soften the blow that Karen Baja dealt to Cam Donaldson by brutally killing his father. Karen Baja was motivated by her relationship with Lou Donaldson and her greed to murder him. Because of that murder, Cam Donaldson has been in a state of mourning and incalculable suffering. Today, we've proven all four elements of wrongful death. First, that Lou Donaldson was dead. Second, that Lou Donaldson's death was caused by Karen Baja's intentional or reckless conduct. Third, that Cam Donaldson suffered injuries, damages, or losses because of Lou Donaldson's death. And fourth, that Karen Baja's conduct caused Cam Donaldson's injuries or damages. When someone steals something, they must be held accountable. Members of the jury, hold Karen Baja accountable today. Find her liable in the amount of $35 million. Thank you.
All right, thank you, Ms. DeMeglio. I think you have about 3 minutes, 3.5. Okay, if 2 minutes and 45 seconds, we'll call it 3 for your rebuttal. I will stop you hard at the 3. Mr. Aguiar, got that right?
Yes, Aguiar.
You have plenty of time. You have 46 minutes. If you take that, I will cut you off.
I will not take it, Your Honor, I promise.
Okay, whenever you're ready.
Your Honor, opposing counsel, members of the jury, nothing was ever enough for Mr. Donaldson. Now, the plaintiff this came before you, and they try to tell you that Karen Beja, a loving mother and a caring wife, allegedly killed her husband without anybody noticing, without anybody witnessing it, and with no DNA evidence whatsoever. It's because she didn't, members of the jury, but unfortunately, she was never enough for Mr. Donaldson. You heard testimony. Mr. Donaldson had a mistress, and he often flew to Costa Rica. And the reason why he didn't log a flight plan on August 17th of 2012 is because he wanted no one to know where he was going. He wanted to permanently be with his mistress because nothing was ever enough for Mr. Donaldson. Opposing counsel would have you believe that he's dead because he hasn't touched his bank account in 5 years. But think back, members of the jury, to Cam Donaldson's testimony. You heard how Mr. Donaldson made a fortune selling used cars. He made a fortune when he built Wild Wildlife. But you don't have to take my word for it. His bank account shows just that. You'll see that in Mr. Donaldson's bank account, he had over $90,000. So what's more likely? The fact that a caring mother and wife somehow murdered her husband without anybody noticing, with there being no DNA evidence, without any witness being able to attest to that? Or the fact that Mr. Donaldson flew somewhere where he's been beforehand with his mistress and started a business? Something that he's done prior beforehand. Something he's done to success and that he's practiced. We, the defense, bear no burden of proof in today's case. That lies solely upon the plaintiff. And they had to prove to you 4 elements by preponderance of the evidence. They had to prove to you 4 elements more likely than not. And that first element is that Mr. Donaldson is dead. And we can stop right there, members of the jury, because they have not met that element in today's case. But even if you were to find that they did, they have not met the remaining 3. And that second element is that Karen killed Lou. The third one is that Cam suffered damages as a result. And the fourth is that Karen's conduct, whether intentional or recklessly, led to Cam's suffrage. Now, opposing counsel came before you and they tried to guess as to how Mr. Donaldson died without giving any concrete evidence. It makes it hard to believe that they met their element even by a preponderance of the evidence. You heard testimony about this meat grinder, but there was no DNA evidence found. There was no hair follicles. There was no blood residue. There's nothing on it, members of the jury, because it wasn't used. They couldn't even tell you when they used it. They couldn't tell you a time and place of Mr. Donaldson's death. They didn't bring to you a body, an autopsy report. They brought to you no proof of Mr. Donaldson's death. They tried to tell you that she co-conspired with her brother. But members of the jury, no one saw them with Mr. Donaldson. No one actually even knows where Mr. Donaldson was at the time or any time at all. They had to prove to you these things, but they failed to do so. Next, they argued damages. Now let's go over that. Now, members of the jury, there's only ever been the one will. And Chris Renard told you that. someone with 20 plus years of experience, someone whose job it is to find any grounds to contest payment for the life insurance policy, found none. You heard how he had a bachelor's degree, how he's been doing this for 20 plus years. An opposing counsel would have you believe that Taylor Pride can convince you otherwise. But think back to Mrs. Pride's credentials. She has no specialized degrees. The only board certification that she has took just 2 weeks. 2 weeks, members of the jury. That doesn't make someone an expert. That doesn't give you anything to believe that Chris Renard is wrong. Therefore, they haven't met that element in today's case. They haven't proved evidence of another will. No other witness can attest to it. There's no record of it, no documentation, nothing. No one else can attest to it. The only person who disputes it is the same person who stands to gain something, Cam Donaldson. They would have you believe he's mourning over his father's death, but he isn't, members of the jury. That's why he waited 5 years to hire Taylor Pride. He waited 5 years because he figured it was finally time, because nothing was enough for him, just like how nothing was enough for his father. Therefore, they have failed to meet that element. They would have you believe that Mr. Donaldson was frightened by his wife. But members of the jury, let me remind you, that restraining order was denied. If he were actually frightened by his wife, you would have heard testimony that he moved in with his son, that he called 911. No, you never heard that testimony, members of the jury, because he wasn't afraid of his wife, nor was he scared of her. If he were frightened, he would have done something. Cam would have told you on the stand that he moved out. Did he do that? No, he didn't. But nothing was ever enough for Mr. Donaldson. Karen, unfortunately, was not enough, and that's why he fled with his mistress. That is why we ask that you find Karen Beja not liable for the wrongful death of Mr. Donaldson. And that is why we ask that you award Cam Donaldson $0 in damages. Thank you.
All right, thank you. Ms. DeMeglio, you have 3 minutes for rebuttal.
Yes, Your Honor. The defense just tried to tell you that nothing was ever enough for Lou Donaldson. But in reality, nothing was ever enough for Karen Baja. She couldn't accept that her husband wanted a divorce, that their marriage was failing. She couldn't accept that Cam Donaldson was supposed to inherit the business that his father built for him. She couldn't accept a quarter share of her husband's assets. No, nothing was enough. She had to have it all. That's why she murdered Lou Donaldson, because she was motivated by her greed and her relationship with him. Because of that murder, Cam Donaldson has been in a state of mourning. Find Karen Baja liable in the amount of $35 million. Thank you.
All right, thank you. At this point, we will submit the case to the jury, and your work here is done. Round of applause to the advocates. I know that this is just such a different year for everyone. It's so weird to be doing these trials. You guys did a great job. You should all be very proud of yourselves. You don't have to listen to our feedback now, which is great. You do have your juror insight forms, which you guys will get. So I just want to thank you guys. I thought everyone did a good job. I'm one of the trial team coaches at the University of Denver, and I helped write this case problem, so sorry. But I thought everyone did a great job, and it was wonderful to see this happen, and hopefully next year we'll all be back in person. And I wish you guys the best of luck. Jurors, before I release the advocates, we're not doing feedback or anything, but do you have any questions for them in terms of team names, spelling of anything, or are we good? I think that means we are good. All right, well, have a good rest of your night and good luck throughout the rest of the competition. And let us know if you guys need anything.
Thank you very much.
Thank you.
Thank you.
Thank you.